profit corporation. It had almost no corporate money in its treasury. It was mostly individual contributions. However, after the court heard argument in the case, it did a very unusual thing and decided it wouldn't decide the case. It wanted to hear re-argument. And the court reached out and asked the parties to brief whether or not they should, one, overrule Austin versus Michigan Chamber of Commerce, and two, overrule that part of McCain-Feingold, which basically prohibited sham issue advertising totally, which they had almost already done in the Wisconsin case. And they set the case for special argument last September, even before the new term of the Supreme Court had started. It was a very unusual procedure, and it was very obvious that the 5-member majority of the court was dead set on changing the law, on promoting and permitting corporate expenditures in political campaigns. And of course, there's a 200-page, yeah.
Would it be unfair to call that being an activist court?
It is a very activist court. It was very, very activist, no question about it. And Justice Stevens wrote a 90-page dissent saying just that, denouncing the majority for what they had done, that it was unprecedented, and that they had totally ignored a dozen different precedents in reaching out to decide this case the way they did. The most disturbing aspects, I think, of the Citizens United opinion, and it's a lengthy opinion by Justice Kennedy, is this notion that business corporations are nothing but associations of citizens. They treat them, this is a right of association, that people associate in the corporate form to make money. That they're no different than any other association. Refuse to accept the distinction which Justices Marshall and Brennan had so artfully established back in Austin and in MCFL about this basic distinction between business corporations, which get special advantages under the law in order to amass money and get all kinds of legal benefits out of this, that they are different from an ideological corporation which people join voluntarily because they believe in the ideas and the ideology of the association. But in Citizens United, Justice Kennedy disowns that idea and insists that a business corporation, that ExxonMobil or Pfizer or what have you are nothing but associations of citizens which have First Amendment rights. And 5 members of the court joined this with a straight face. And Justice Stevens' dissent, and as I said, Justice Stevens' dissent is, I think, a masterful dissent, very angry dissent. He was so angry he read much of it in the court that morning, which is fairly unusual to read your dissent. This is one of the things he says. The conceit that for-profit corporations must be treated identically to natural persons in the political sphere is not only inaccurate, but also inadequate to justify the court's disposition of this case. In the context of election to public office, the distinction between corporate and human speakers is significant. Although they make enormous contributions to our society, corporations are not actually members of it. They cannot vote or run for office. Because they may be managed and controlled by non-residents, their interests may conflict in fundamental respects with the interest of eligible voters. The financial resources, legal structure, and instrumental orientation of corporations raise legitimate concerns about their role in the electoral process. And then he says, people who invest in business corporations, as opposed to contributors to ideological nonprofits, don't typically intend thereby to authorize the managers and directors of those corporations to use the money invested in their businesses to help some candidate to an election to federal office or to hinder the efforts of others vying for positions of federal authority. Talking about a business corporation as merely another way that individuals might choose to organize their associations with one another to pursue their common expressive aims is worse than unrealistic. Indeed, it was as way back as 1816 that Chief Justice John Marshall, in a famous case involving Dartmouth College, said, "A corporation is an artificial being, invisible, intangible, and existing only in contemplation of law. Being the mere creature of law, it possesses only those properties which make the charter of creation, confers upon it." Interestingly enough, that notion about the artificiality of corporations and the fact that they have no rights other than those which their creator confers upon it was articulated very forcefully 25 years ago by none other than Justice William Rehnquist. Before he joined his conservative brethren and changed his position, which he did in later life, he was an ardent opponent of the notion that corporations had rights of free speech. Indeed, the notion that corporate rights of free speech is actually, or have any constitutional rights, is an anachronism from a case in 1886 involving, it's called Santa Clara versus, some railroad.
Southern Pacific.
Yeah, Pacific. In which the Chief Justice, in introducing the case, made some comment about corporations have constitutional rights. It was never mentioned in the actual opinion of the case, but the court reporter reported it as if it were law, that corporations have constitutional rights. It was a total anachronism, which 25 years later, conservative Supreme Court justices picked up on to protect rights of business corporations in the political, well, mostly the economic sphere. But Justice Rehnquist had opposed that vigorously in his early. In fact, it was very interesting. The case in which Justice Rehnquist made his position was actually a case called Bellotti versus First National Bank of Boston. And that was a case which involved a referendum. And the Massachusetts legislature had forbidden, I guess it was all banks, or just banks or all corporations, from spending money to support referenda in Massachusetts. And actually, Justice Stevens, who now dissented in Citizens United, wrote the dissent, actually was part of the majority in Bellotti. And Justice Rehnquist was part of the dissent, was the dissenter. And in Citizens United, Justice Stevens says, in fact, he has an interesting quote here somewhere, I'm not sure where I can find it. He talks about the difference between Bellotti and Citizens United, and makes the point, I think I know where this quote is, so I can find it. In his Citizens United dissent, he distinguishes Bellotti, and he says, a referendum cannot owe a political debt to a corporation.